All right, good afternoon, everyone. My name is Grace Dinger, and I'm a staff attorney in the General Law Unit of the Downtown Office of Atlanta Legal Aid. Legal Aid is a nonprofit law firm, and we only handle civil cases, not criminal cases. We have several different offices across the metro Atlanta area. And if you have questions about a civil legal issue, you can contact Legal Aid by phone or online to go through our intake process and find out if you are eligible for our services. Our main phone number is 404-524-5811, and our website is atlantalegalaid.org. Today's presentation is a general presentation about Georgia unemployment law, and it may not directly apply to the facts of your case because every case is different. For specific legal advice, please contact an attorney for an individual consultation. This presentation also does not create any kind of attorney-client relationship. The information that you'll hear today is Georgia specific for any non-Georgia viewers who may be watching today. And if you have a question while I'm talking, please just type it into the comment box and we will answer questions at the end. And we'll also be putting some helpful links in the comments during the presentation, so be on the lookout for those. So to get started, you'll often see unemployment insurance benefits abbreviated as UI or UIB. Unemployment is a short-term monetary benefit for people who were working W-2 jobs who are now unemployed through no fault of their own. Usually this means that you were laid off, you were fired for a reason that was not your fault, or you had to quit for what's called a good work-connected reason. Unemployment is very different from other programs that you may be familiar with, like Social Security retirement, where you pay into the system by having money taken out of your paychecks. For unemployment benefits, the money is mainly coming from taxes that your employer pays. So that's why only W-2 wage earners can get these kind of benefits. So to go into a few examples of reasons why you might be eligible for benefits, being laid off is pretty straightforward. Usually that means that there was no work for you to do and your employer lets you go. Firing and quitting can get a lot more complicated, and a lot of times it's the employee and the employer's words against each other about what really happened. Like I said, every case is different, so if you want advice on the specific facts of your case, you should definitely speak with a lawyer, but I can give a few general examples. One reason that you may be fired is for failure to follow rules at your job, but you could possibly still get benefits if you can prove that you were never informed about the rule, that you were never informed that your behavior was breaking a rule, or that the behavior was widely accepted in the workplace, even if it was technically against a rule. You could also possibly still get benefits if you voluntarily quit your job, if you can show that you quit for a good work-connected cause. One example of this is a medical issue. If you have an injury or a health issue that prevents you from being able to do the kind of work that you used to do, and you talk to your employer to try to work something out and see if there's anything that you can physically still do at your job, and there's just not anything like that there, you could possibly still get benefits if you then had to quit that job. Another example is a drastic change in expectations. So for example, if you agreed only to work during the day while your kids are at school, but now your employer is only putting you on night shifts and you can't work at night, that could be a good reason to quit and still get benefits. And one last example is being in a hostile work environment. If you're being abused at work in a way that a reasonable person would not put up with, then you could possibly quit and still get benefits. This situation can also apply if you have to leave a job due to fleeing a domestic violence situation. And again, these are just general examples and are not always going to be a reason why you can get benefits. It's a very fact-specific question. So you apply for benefits, usually online, and you do this after you become separated from your job. We're going to put a link in the comments so that you can access that application if you need it. On the application, you're going to provide information about yourself, wages that you've earned, and why you lost your most recent job, and how you would like to receive benefits if you get approved for them. Usually that's going to either be direct deposit into a bank account or on a debit card that gets mailed out to you. Sometimes your employer will be the one to apply for benefits for you. Usually they'll tell you if they're doing this, and it's a situation where they're laying off multiple people and filing everyone's claims at the same time. but most of the time, the individual is going to be the one filing the application for themselves. Unemployment benefits are administered by the Department of Labor, which you'll hear me refer to in this presentation as DOL. They use an online portal system where you'll set up a username and a PIN number, and you can log in to see information about your claim. So soon after you apply, you should get a letter in the mail that's called a benefit determination letter. And I really want to explain what this letter means because there's often a lot of misunderstanding around it. This letter is going to show a weekly benefit amount, or WBA, on it. In Georgia, the highest weekly benefit amount available is $365. Now, most people see this letter and they assume that because it has a dollar amount on it that they've been approved for benefits, but that is not what this letter means. This letter only means that they have calculated how much you will get if you are approved for benefits, but they haven't actually made that decision yet, so it can be very confusing. The letter is going to show your wages for a 4-quarter period. They determine your weekly benefit amount based on the amount of wages that you earned during the first 4 of the previous 5 quarters. Now, what does that mean? So let's say if you were to apply for benefits today, October 20th, we're in the 4th quarter of 2022. So the 4 quarters of wages they'd be looking at are the last 2 quarters of 2021 and the first 2 quarters of 2022. Each quarter is a 3-month period. So for that example, the quarters they'd be looking at would be July 2021 through June 2022. So whatever quarter that we're in right now, you look backwards, skip 1, and then it's those next 4. You want to look really carefully at the wages that they have listed for you during these quarters to make sure that there aren't any missing. If you had multiple jobs during this period, you want to make sure that all of the jobs are represented on there. A big exception to that is that the letter will not show any wages besides W-2 wages. So this means no wages from self-employment and no wages from 1099 jobs or gig jobs or most jobs where you get paid in cash. If everything on the letter looks correct, then you'll wait until you get a second letter making the actual decision on your eligibility. If there's a mistake on the letter, you need to file an appeal right away. And we can talk more about how to do that shortly when we get into more details on appeals. So the decision that either actually grants or denies you benefits is called a claims examiner's decision, and you'll sometimes see that abbreviated as a CED. This is the letter that will tell you whether or not you're going to get the money that was listed on the first letter. The claims examiner's determination will explain why or why not you can get the benefits. Usually this will come anywhere from a few weeks to a few months after that first letter. So just be watching your mail because all of these letters are going to be sent through the mail. If the letter grants you benefits, then great, you should be receiving the money shortly. If your employer disagrees with this decision, they have the right to file an appeal, but they have to wait for their appeal to be heard just like you do. So if they appeal, that shouldn't stop you from getting the money now. If the letter denies you benefits, you'll want to file an appeal right away. And again, we're going to talk about appeals in a lot of detail in just a few minutes. So while your benefit determination letter that we talked about first, that's going to be based on all of the wages during those 4 quarters, which could be several different jobs. But the decision of whether or not you're granted benefits is only going to be based on one job. And that's your most recent employer, which is generally just going to be the last place that you worked before you became unemployed. Before we get into appeals, I do want to talk a little bit about continuing requirements. So these are the things that you have to do every single week while you have an open unemployment claim. You do it while you're waiting for the first letter, you do it while you're waiting for the second letter, and you keep doing it after that. And there are 2 things you have to do: certifying and work searches. I recommend doing both of these at the same time every week so that you don't forget. Certifying means either going online or calling in every week to ask for the benefits. If you don't ask for the benefits every week, you will not get them. You usually can't start doing this until after your claim is processed, which should only take a few days after you file it. By certifying, you're telling the Department of Labor that you are still unemployed, that you are able to work, and that you are actively seeking work. You will also disclose if you have earned any money that week. The certifying process should take less than 5 minutes, but you have to remember to do it every week. So it might be helpful to set a reminder on your phone or write it down on a calendar so that you remember to do it every week. The other thing, in addition to certifying, is to complete the work search requirements. Now, this was a requirement that went away for a while during the pandemic, but it is back now. So it is not optional, and you have to make sure you're doing the work search requirement every week. The work search website is called Employ Georgia, and there's a link to that on the homepage of DOL's website. So what you have to do is set up an account with Employ Georgia, and on there you're going to upload your resume, and you're going to submit 3 work searches every week to show DOL that you are looking for jobs. And the website will explain how to do that. Now, a lot of people might think that it's okay to just use another website to fulfill the work search requirement, but that is not the case. If you're using LinkedIn, ZipRecruiter, or any other website as your primary way to look for jobs, that is absolutely fine. You just have to make sure that you're also using Employ Georgia so that DOL can see that you're looking for jobs. Even if you only do 3 every week on there and use other websites for most of your job research, that's fine. You just have to make sure you do at least 3. Partial claims. So a partial claim is when you don't lose your job completely, but your hours are reduced and maybe your employer won't let you work as much as you want to. Depending on the amount of hours that you're working, you may be considered underemployed and eligible to file a partial claim. The most important part of having a partial claim is that you are reporting your wages accurately when you go in to certify every week. So when you're asked if you worked that week, if the answer is yes, you'll be asked how much money did you earn, and you have to be 100% accurate. Now the question is how much money did you earn, not how much money did you get paid, and this is an important difference. So let's say you get paid every 2 weeks, and right now you're certifying for week number 1. You have to report how much money you earned that week by working, even if you don't actually get your paycheck until the following week. And DOL will be checking to make sure that what you report matches their records. And if it doesn't, your benefits may be cut off and you may be accused of fraud, even if it was an honest mistake. So it's really important to keep accurate records about what you're earning if you're still working while you have an open claim. And before we get into appeals, I did want to briefly touch on some of the specific pandemic programs that came out in 2020. So the main one is PUA, and PUA stands for Pandemic Unemployment Assistance. And it was created at the beginning of the COVID-19 pandemic by the federal government. PUA allowed people to get unemployment who normally weren't eligible for it, like gig workers and self-employed workers. This included jobs like Uber or Lyft drivers and some musicians and other performers, for example. This program ended in Georgia at the end of June 2021, so no one can get PUA for any weeks after that date. The reason that we're still talking about it more than a year later is because a lot of people still have pending appeals out there for PUA. If you win your appeal and you get back pay for PUA, it will only be for weeks that happened before the end of June 2021. Another important note about PUA is that your employer really has nothing to lose if you get these benefits because the money came from the federal government. So if you have a PUA appeal, your employer will actually not even be part of that hearing. It will just be you and DOL. The thing about unemployment, especially in the past couple of years, is that there are a lot of acronyms. Most of these acronyms were for programs that are now over, but I just wanted to run through a few of them briefly just to explain what they are so that you know what they mean when you see them on your online portal or on one of your decisions. So FPUC, that was a federal supplement that people got on top of their weekly benefits for a while during the pandemic. At one point, it was $600 extra, and then later it changed to $300 extra. This program was on and off for a while, but it did stop completely at the same time as PUA, so that's the end of June 2021. PEUC, that was the same as regular unemployment. It just extended the number of weeks because most people were unemployed for a lot longer than they normally would be during the pandemic. So once your normal amount of weeks ran out, it switched to being called PEUC for the extra weeks, but it was still the same amount, just with a different name. So that one wasn't a supplement. And then one more is LWA. This was a $300 supplement that was only around for about 6 weeks in the summer of 2020. If you're still pursuing appeals for this time period that the FPUC supplement and the PEUC extended weeks were in place, you'll still get those if you win your appeal. But specifically with LWA, that money has ran out. So even if your appeal covered that time period, you unfortunately can't get those benefits now. But luckily that was a really short time period, so it wasn't that much money. There are other acronyms, and if you have a question about one that you see on your portal or on one of your decisions, please just put it in the comments, and towards the end, we will look to questions and I will try to interpret any of those acronyms for you. Those are just some of the major ones that I wanted to cover. So let's talk about unemployment appeals. Almost every decision that you receive from the Department of Labor has an appeal deadline of only 15 days. That's why it's so important to check your mail every day to make sure that by the time you see a letter, it isn't already more than 15 days later and you've missed your appeal deadline. There are 3 different ways to submit an appeal when you receive a decision that you disagree with. One of them is fax, which I do not recommend. It's very easy to lose both the fax and any proof that you sent the fax. Option 2 is to appeal through your online portal. This option gives you a confirmation number at the end. So you have to make sure that you either take a screenshot or print this out or write it down so that you have that confirmation number. Option 3 is by email, which is what I usually recommend. If you send your appeal by email, you will have a record of it in your sent emails, and you will receive an automated response email confirming that your email was received. Hang on to all of these emails because they will show exactly when you submitted your appeal if there's ever a question later about whether your appeal was submitted within those 15 days. Now, the email address that you'll be sending your appeals to, and we'll put this in the comments as well, is appeals@gdol.ga.gov. Now, what should you put in an appeal email? You don't have to put very much, but you have to put enough so that it's very clear who you are and what you're talking about. You will put your first and last name and the last 4 digits of your social security number. You'll put your contact information and a short statement saying that you are appealing the decision and give the date on the decision that you're appealing. That's all you have to do. You don't have to write out a long explanation or attach any evidence. You will have time to do that later. The appeal email itself should be short and sweet so that it's very clear that this is an appeal. Now, how long will it take for your appeal to be heard? DOL is extremely backed up because of the pandemic. So we are seeing appeals take significantly more than a year between when they're filed and when the hearing is scheduled. There's unfortunately nothing that legal aid or anyone else can do to make that timeline move faster for anyone. But while you're waiting, you have to keep certifying and keep doing the work searches every week. Because if you eventually win your appeal, you'll only get paid for the weeks that you're eligible. And the only weeks that you could be eligible are the weeks where you certified and did your work searches. Since a lot of time is going to go by between when you file your appeal and when you have your hearing, the number one thing to remember during this waiting time is to keep DOL updated with any changes to your contact information. This means your address, your phone number, or your email address. If any of these change, you should update them immediately in 2 places: on your online portal and by sending an email to appeals. Again, that email address is appeals@gdol.ga.gov. If you don't update your information and you miss an important letter or a phone call because they mailed something to your old address or they called you on your old phone number, you're going to be out of luck if you didn't give them the new information. Also, on that point, do not rely on mail forwarding if you move because that doesn't always work. Just make sure they have the new correct address where you can check your mail every day. When your appeal hearing is coming up soon, you'll find out because you'll receive a packet of documents from DOL about your case in the mail. And shortly after that, usually just a few days later, you'll receive a hearing notice telling you the date and time of your hearing. It will list your phone number on there, so make sure that that number is still correct. The notice will have instructions on there for how to submit any evidence you have before your hearing. If you're interested in getting legal advice and possible representation for your hearing, make sure that you reach out as soon as you get that appeal packet of documents so that an attorney has enough time to determine whether they can help you out. It's also important to note that you don't have to be an attorney to represent someone at an unemployment appeal hearing. So if you are not eligible for our services or we're not able to help you out and you have a friend or family member, they can represent you. You don't have to be a lawyer to do that. When it's time for your hearing, DOL will call you on the phone at the scheduled time. Make sure that you're in a quiet place with good cell service, with a charged phone, and that you're by yourself. They may not let the hearing go forward if there's a lot of background noise. Your hearing will probably last about 1 hour. Even though it's a phone call, you need to treat it like you're going to court and talking to a judge because you will be put under oath and swear to tell the truth. The hearing will be recorded, so don't say anything that you might regret later. The hearing officer will ask you questions. If your employer is there, they will ask you questions as well, and you'll have the opportunity to ask them questions. And then both parties are able to make a closing statement at the end. The most important thing to remember with these hearings is that you need to get everything on the record. This means you have to say everything you want to say and submit any documents that you have. If you lose and you have to appeal further, the next level is only allowed to look at what happened at the hearing. So if there's anything that might be important to the outcome of your case, you need to make sure that it gets talked about at the phone hearing because they can't consider it later if you didn't get it in at the hearing and you could have. If you have any witnesses, you will tell the hearing officer that, and they will call your witnesses when it is their turn to testify. Make sure your witnesses are ready to answer their phones and that you've talked with them about what you expect them to say. You're allowed to object to things that your employer says during the hearing, and we don't have time today to give a full evidence lesson on all of the possible things you may be able to object to, but I do want to highlight a couple that I see a lot in these hearings. Often the person testifying for the employer is someone that works in the HR department. You may have never even met this person before. It's possible that they even started working there after you left, since the time between filing your appeal and waiting for your hearing is so long. If you do not know the person who is testifying for your employer, you want to object if they start talking about things that they do not have personal knowledge of. For example, maybe everything this person knows about why you lost your job, they only know because they read it on a piece of paper or someone else told them. They don't have personal knowledge of what happened if they weren't there. You have that knowledge because you were there, so you can object to that. Another possible objection is hearsay. The hearsay rules are very complicated, and it's not like on TV where you can just say hearsay anytime that you don't agree with what someone's saying. The most simple definition of hearsay is when someone's talking about what someone else said and the person who said it is not present. There are a lot of exceptions to this rule that we don't have time to get into, but you should try objecting to hearsay if someone is quoting someone else and the person being quoted is not there. A special kind of appeal hearing is a show cause appeal hearing. So these come into play if you miss your hearing date. If you know as soon as you get your hearing notice that you're not going to be available on that day at that time, you should make every effort possible to let the Department of Labor know ahead of time to see if they'll let you reschedule it. You have to have a really, really good reason to miss your hearing. So it can't be a pretty normal situation like you have work or you have to pick up your kids or you have a doctor's appointment. DOL is going to expect you to move those kind of obligations around to be there, just like if you had a court date. A good reason for missing your hearing has to be a true emergency. And hopefully that doesn't happen. But if it does, and something happens that day and you just cannot answer the phone and participate, the hearing will likely go forward without you. A decision will be released in the mail and it's likely not going to be in your favor. And then you can submit what's called a show cause appeal. A show cause appeal means that another hearing will be scheduled and you will have to explain why you missed your first hearing. If DOL thinks that you had a good reason to miss it, then they'll let you talk about the actual merits of your case. But if they think that you didn't have a good reason to miss, they won't make a new decision on your case because you didn't show good cause for missing the first hearing date. That same rule applies if you filed your appeal after the 15-day deadline. If they find that you had a good reason to miss the deadline, they'll go ahead. But If they find that you didn't have a good reason to miss the deadline, they will not make a decision on the actual case because the appeal was late. Whichever party loses at the phone hearing stage has the opportunity to file an appeal to the Board of Review. Again, that's going to be within 15 days of receiving the new decision. So if you've just had your hearing, make sure that you're checking your mail every day, waiting for that decision so that if you lose, you don't miss your next appeal deadline. If you're appealing to the Board of Review, you want to contact them and ask them for a copy of the CD recording of your hearing, which will be mailed to you. Listening to that CD may help you remember everything that was said during the hearing and figure out what arguments you want to focus on for this appeal. You can also submit a written statement in support of your appeal, but there will not be a new hearing at this stage. Again, they're only going to look at what happened during the phone hearing, so that's why it's important to get all your evidence on the record the first time. Now, whoever loses at the Board of Review, the next level of review is where you would file a case into Superior Court of the county where you were last employed. And this is the deadline that is not 15 days. This one is 30 days. So after you receive a decision from the Board of Review, if you disagree, you have 30 days to go to the Superior Court and file a court case. When the court is reviewing your case, they're going to be held to a standard called any evidence. And this is a really strict standard. It basically means that they can't overturn the DOL's decision if there is any evidence, even just a little bit, to support it. So it's a pretty high standard. If you lose at Superior Court, the next level after that is the Court of Appeals of Georgia. This court isn't required to let you appeal. So if you haven't gotten a lawyer involved yet, you probably want to at this point to get real advice on if there is enough evidence in the record of your case so that the Court of Appeals would consider your case. I know that was a lot on appeals. There's a couple other things that I do want to cover, but if you have appeal questions, please put them in the comments and we will try to answer them at the end. All right, overpayments. I did want to talk a little bit about this. So we're seeing a lot of unemployment overpayments these days. And this means that DOL gave you benefits, but then later decided for some reason that they shouldn't have and are trying to get that money back from you. This could happen months or years after you got the benefits, so you might not have them anymore because you probably already spent them. They may start taking actions like intercepting your tax return to cover the overpayment. If you don't think that you owe the money back, you should file an appeal of an overpayment decision the same way you'd file an appeal of any other decision within 15 days. You can also request a waiver. A waiver isn't necessarily saying that you don't owe the money. A waiver is saying, even if I do owe the money, I shouldn't have to pay it back because I can't afford to, and the fact that I was overpaid was not my fault. You can file both an appeal and a waiver just to cover all your bases. Waiver applications are available online, and we're going to put a link to that in the comments. You should be as detailed and truthful as possible about your income and expenses on a waiver application to show the Department of Labor that you cannot afford to give them the money back if that's the case. One other concept I really wanted to talk about is benefit years. So another acronym on all of your decisions from DOL, you'll probably see the following abbreviations: BYB, which stands for benefit year begin, and BYE, which stands for benefit year end. Your benefit year begins when you file your claim for unemployment. If your benefit year ends and you're still unemployed or underemployed, you must start over with a new application in order to start a new benefit year. Keep in mind that they will be looking at different quarters of wages this time because it's always going to be the first 4 of the previous 5 from when you filed. So if you never return to work, you're not going to have any wages to calculate a new weekly benefit amount this time. So you can't get benefits, unfortunately. If your benefit year ends and you're still waiting for your appeal hearing, they will get to it. But if you want to keep claiming weeks after your benefit year ends, you need to start over with a new application. You also may have reason to file a new claim during the same benefit year if you went back to work and then became separated from a new employer. Anytime that you're becoming separated from a different employer, you have to file a new claim regardless of if you're still in the same benefit year or if you're in a new benefit year. The Department of Labor Career Centers, they are located throughout the state, and